Hello everybody and welcome to this next webinar in our series of free landlord law lockdown training. And this webinar is with our regular speaker, Solicitor David Smith of JMW Solicitors. And David is going to talk to us about 7 things to watch out for with company lets. So welcome, David.
Hi, yes, I'm back yet again.
Perhaps we better check first to make sure that everybody can hear us. So if you could just sort of indicate in the chat box that you can actually hear us. If you've got any questions, put them in the chat box. We've only got a limited time for this webinar, so we may not have time to answer them, but we will if we can. So take it away, David.
Great, somebody can hear me, that's good. Yes,
yeah.
A couple of people can hear us at least. Right, so I'm going to talk a little bit about company lets, which are one of these things that people get a bit confused about, but are actually in some ways becoming more common again. They used to be quite big and then they faded away and they're sort of back a little bit. So 7 things about company lets. The first thing to think about, I always say, is who the tenant actually is. Are they in fact a company, such as a limited company or a public limited company or an LLP, something that has what we would call standing in a legal sense as a separate legal entity, or are they in fact a sole trading entity? This really controls whether or not it's a company let. So a company let, of course, isn't anything. It's just a term of art that basically means that the tenancy does not fall under the auspices of the Housing Act 1988, because the Housing Act 1988 requires, one, that the tenant is an individual or group of individuals. So a limited company is clearly not an individual or group of individuals. It is a limited company, and it has separate legal standing. And the second requirement is that the tenant must be residing in the property as their own home. Clearly, a company cannot reside in a property as its own home, because it doesn't reside anywhere as such. It resides, I suppose, in its registered office address. So these are the sort of things that push outside the Housing Act 88. But of course, a sole trader is not a company. That is an individual group of individuals. And if they were renting a property for their own use, even if they were using their trading name because they intended to push part of the cost through their company persona for tax purposes, or call it a company expense, they would still potentially have a Housing Act 88 tenancy. So the first question is who is it in fact is the tenant? Are they in fact a company? And more to the point, what's the company name? Make sure you've checked. Lots of people, when they tell you their company name, even when they're a limited company, don't tell it to you correctly. They misstate it or leave out brackets and things like that, and obviously getting it exactly right is important. If it's a limited liability partnership or an LLP, then that's something you need to establish as well, because an LLP, a limited liability partnership, is like a company. It has a legal persona. A simple partnership doesn't have a legal persona. It's a group of individuals, just with a partnership agreement, a trading style. So, for example, my previous law firm, Anthony Gold Solicitors, was a simple partnership. I think it's now become an LLP. Actually, now I've left. JMW Solicitors, where I now work, is an LLP. It's a limited liability partnership. It has a legal persona on its own. So they're different legally. An LLP will always be a company let. A simple partnership might be, but it depends who's occupying the property and for what purpose. Or is it something else altogether? Bear in mind that a limited company could be a Scottish limited company. So it could be limited liability company based in Scotland, which is a different group of companies. It could be a limited company in Jersey or one of the Channel Islands, which is going to affect your position. It could be a limited company in some other completely different jurisdiction, like the Seychelles, for example, or the Virgin Islands, or just a European company. So you'll need to bear that in mind, because it will seriously affect your ability to recover possession, and more to the point, to recover any money off this company. So you just need to be very cautious about where the company's, who the company is. And so when we're talking about a company, it's important to bear in mind that you get the company's full name and their company registration number, and find out in which jurisdiction they're registered, and then check that on the relevant website for that jurisdiction, or the relevant company register for that jurisdiction. Right, the second thing to bear in mind is the tenant actually a good risk? I'm always surprised how many landlords just seem to think that all companies are apparently a good risk. The whole point about a limited liability company is it has limited liability, which basically means that the individuals who stand behind it don't have any liability at all for anything that the company does. So if I come to you and say I want to rent a house in my own name and I don't pay the rent, you can sue me. If I come to you and having made up a company, which I can do for 40 odd pounds through online through a company supplier, I can get a company produced for 40, 50 quid within a day or so, and I come to you with that company and say I want to rent the house and I don't pay the rent, there's nothing that you can do to me. You'll have to go after the company. The company's probably got no money. So some people seem to be enormously generous to companies in terms of their risk factors. So companies may be an appallingly poor risk. And the first question I'd always ask about a company if you were going to let them is, how long have they been trading? And of course, I would check that on the Companies House website. I'm amazed how often people will simply let to companies that have been trading for a year, as if they're in some way, a genuine and productive company that you should think is a good risk when there's simply no evidence of that. You need to look at their accounts. Companies House, they'll have their accounts filed. You should take a look at them, make sure they actually have filed their accounts, and you should be trying to look at how much money they're making. It will give you an indication of what they're making. You may want to seek references. People don't bother seeking references in respect of limited companies, but accountants' references, bank references would be appropriate. You can get a credit check done on a limited company, although they're quite pricey, but they are available. And they're more complex, I hasten to add, than the ones that you would do for individuals, but they can be done. And of course, if you're not sure at all, the correct thing to do would be to seek personal guarantees from the individual directors of the company. So just like any other situation where you ask for a tenant to provide a guarantor, there's no reason why you can't ask a company tenant to provide a guarantor. And in many cases, I think that's a good thing to do. I'm kind of surprised that people don't do it more often. The next question, think about in respect to companies, what are they actually doing with this property? What's the purpose of it? Why are you renting it through the company at all? Is it just to be is the company basically the directors? Is it they're just their legal persona for other purposes, and they're using it to house themselves and putting it through a company for tax purposes? That's one possibility. Are they using it to house employees of the company? In which case, the immediate question I would want to ask is, which employees? Are you talking about a senior employee with their family, in which case less of a problem? Or are you talking about, for example, renting a property because I run a restaurant and I want to house all my kitchen staff? I've seen that one a few times. In which case, the chances are the property is a house of multiple occupation. So which employees, how many of those employees? Are you going to be changing the employees during the tenancy, or is it a fixed group of employees? Will the agreement allow them to make changes to the employees, and in what context? So you need to be very careful about this. I've seen lots of cases where people rented properties to a company with the understanding that it was going to be one family in there, and then the company decided not to use it that way and simply put loads of other people in without bothering to tell them. Or in fact, the person knew full well there were lots of people going in there and didn't know what, but didn't think to do anything about it. So which employees are you talking about? And potentially, does that make the property an HMO? Is it multiply occupied? You should also be cautious that, of course, a company-let agreement is just also in what's used by most rent-to-renters. A rent-to-renter essentially is going to be taking a company-let tenancy. and obviously a totally different discussion, one to be wary of. I've spoken about rent to rent extensively, including at a recent conference for Tessa, and I think Tess will probably jump in and say here, but some of those lectures are online. I think people want to watch them.
Yeah, it's available as a product. You can buy the rent to rent course and watch all the very interesting talks that David and his colleagues did, and also there's a rent to rent tenancy agreement that you can buy as part of that if you want to. So that is available. There's a link to it from the homepage of Landlord Law.
Great, thank you, Tessa. So rent to rent obviously is a type of company let in a way, in that a company is renting the property and then subletting it, which is what all company lets are essentially, because the company can't live there itself. It's going to be sub-licensing or subletting it in some way. But obviously a totally different type of discussion from a company renting property to put a couple of their employees in. It's a wildly different scenario if they're renting your property with the intention of subletting it to all and sundry. And obviously one to be much more wary of. And of course, particularly at the moment, you should be quite wary of that business model. There are problems with it. It's tough for those. I mean, that's not to say that there aren't good rent-to-renters who are operating a perfectly legitimate business model right now, but some of them are facing hard times, and that's problematic. And as I've already indicated, you need to watch out for changes. It's all very well to say I'm renting it to a couple, but you need to make sure that the company doesn't change on you. So the agreement should make sure that they can't make changes to the occupiers without telling you. And you should be checking up on that when you do inspections as to who's actually in the property, and is it still the people you expect to be in the property, or is it some other totally different group of people? And if so, what the hell is going on? What about licensing? A lot of people seem to think that company let agreements are in some way immune from property licensing. That is absolutely not true. If you're in a selective licensing area, you're still going to need a selective license because you've let it as a company let. If you're in an HMO licensing area, again, you're going to need an HMO license if the company uses the property as an HMO. And it's not open to a landlord to simply turn around and say, oh, I let it to one company, it's a company let. It's nothing to do with me what they do with it. That's not an acceptable position. The obligation to license remains with the landlord. So it may well be that if you let to a company and the company then stuffs it full of six or seven people, they are indeed potentially in breach of the law themselves for operating as an HMO, but so are you. And the local authority will generally go after both of you. And they will always go after the landlord as a rule anyway. So if the company has told you they're going to obtain an HMO license because they're going to use it as an HMO, you need to actually make sure they do that. Your agreement should, one, specify they're going to obtain the license. Two, should require them to provide a copy of the license application, evidence has been filed. And three, should require them to provide a copy of the license when they get it. So you should be following that process through. If it's a selective license, same issue applies. Make sure that if you're getting it, you get it. If the company is meant to be getting it, make sure you have evidence that they're actually doing it. And then obviously, if there is HMO use, which you were not expecting, you need to watch out for it. So if you have done a company let, you do need to be cautious that they haven't just turned it into an HMO. So on inspections, you should be, again, people seem to think that companies shouldn't be inspected. Of course they should. You should still inspect the property. You should be looking out for the possibility that your property has been turned into an HMO. And if it was already meant to be an HMO and you were happy with that, then you should be looking for a misuse of the situation. So if the HMO license allows for 5 people, you need to be watching out for evidence that there's 7 people, and therefore the use has been intensified in breach of the HMO license. So they're all critical issues that you need to consider. Other standards. Repairing obligations don't go away just because it's a company let. Section 11 Landlord Tenant Act 1985 will still apply. So will the Homes Fitness for Human Habitation Act. Gas safety obligations still apply in respect of company lets. EICRs still apply in respect of company lets. The HHSRS still applies in respect of company lets. So your obligation to get a landlord's gas safety certificate or an EICR and to do repairs will not go away as a result of it being a company let. You will need to do all of these things because it's a residential tenancy. Now, tenant fees don't apply. So in fact, you're entitled to charge fees, and the tenancy deposit is not limited to 5 weeks rent in a company let. So you can draft a company let agreement differently, take a higher deposit. You can charge a fixed fee for cleaning, for example. You can charge fees for referencing and all of these things if you're an agent, All of those things are permissible in company lets, and some agents will do that. And of course, tenancy deposit registration doesn't apply because that only applies to ASTs. So there is no requirement to register the deposit with a scheme or any of that stuff. Although, of course, there may be benefits to doing so in terms of accessing free at point of use adjudication, and some of the schemes do offer adjudication for non-AST deposits. But there's no absolute requirement to register with a scheme and to go through all the prescribed information and all that other paperwork type stuff. So don't assume again that standards don't apply. There are still obligations and standards relating to company lets, but there are some critical ones that you don't need to concern yourself with. So what do we do if there's a breach of the agreement? Well, it's not a Housing Act 1988 tenancy, so there is no such thing as a Section 8 notice in respect of company let agreement. If rent has not been paid, then the right to occupy the property is quite limited, and it depends on the forfeiture clause in the tenancy agreement. Now, the critical thing here, of course, is that your tenancy agreement must have a forfeiture clause in. I frequently come across tenancy agreements where it's been removed by the company or by the tenant, or was never in there to begin with. If you do a company let without a forfeiture clause in it, then you will not be able to recover possession during the fixed term for non-payment of rent. You will have to wait till the end of the fixed term, then recover possession, and you can sue the company for money. But you'll have to sit there with the tenants in place not paying you. So it's critical to have a forfeiture clause in a non-Housing Act tenancy. I mean, it's pretty important in a Housing Act tenancy, frankly, but it's critical in a non-Housing Act tenancy because you cannot recover possession of the property for rent arrears without one. The wording of the forfeiture clause will dictate your ability to recover possession. So again, sometimes I see ones where the forfeiture clause has been amended to say that if the rent isn't paid, you can't recover possession until there's been at least 2 weeks of rent arrears. But most forfeiture clauses say that if the rent's at least 14 or 21 days in arrears, then you can recover possession. In terms of the process for rent arrears, you don't actually have to do anything. You can go straight to court and simply issue proceedings for forfeiture. The norm would be to write to them, giving them a short period of time, by which I mean 14 days maximum, to pay the outstanding rent and bring themselves back into agreement. Otherwise, you could simply issue forfeiture proceedings in the county court. As soon as those proceedings are issued, technically the tenancy has ended. However, the landlord is still obligated to carry out their repairing obligations and such things. But the tenancy is effectively forfeited, and then the court will have a possession hearing in order to decide whether the tenancy should remain forfeited or whether they should grant relief from forfeiture. And companies can seek relief from forfeiture, but they will have to pay all of the rent and the interest and all of the legal costs. The thing that always irritates me about company lets is I often see people sitting around waiting for 2 months rent arrears to accrue because they think it's like an AST, and so they have to wait for a certain amount of arrears. That's not true. You can forfeit a company tenancy if the rent is in arrears by £1. And I have in fact done that, and I have seen, and the tenant ended up paying most of the arrears but refused to pay the interest, and the court still forfeited the lease. So the court is very strict about this kind of stuff. If you are in arrears as a company in a tenancy, you're not going to get to keep it. So even less than a month is enough. If it's some other breach of the tenancy agreement, so not rent arrears, then you will have to serve a notice under Section 146 of the Law of Property Act 1925. That's a specialist piece of work, really. And I would strongly advise you to seek legal advice if you're serving a Section 146 notice, because the amount of time that you have to give the tenant is highly variable. It's not based on some fixed piece of statute like it is in the Housing Act 88. It just has to be reasonable, and there are a range of different cases that speak to some of this. So generally it's best to seek specialist advice. So the summary with company-let tenancy agreements is, if there are rent arrears, it's actually much easier to seek possession. If there's some other breach, it's usually a little bit more difficult. Notice periods in respect of Housing Act 88, company lets are not covered by the Housing Act 88, as I've already said. So there's no alteration to any of this stuff due to COVID. You can forfeit these leases and you can still go to court possession. What you can't do at the moment, although we don't know what the new regulations will be from the end of this month, is obtain a bailiff's warrant to evict. But you can get the process started and get a court hearing and seek possession. There are no notice period changes that relate to this kind of stuff. Other types of termination. At the end of a fixed term of a company let agreement, there's no such thing as Section 21 either. So at the end of the fixed term, the tenant's just supposed to go. They are required to leave at the end of the fixed term. If you agree that they can carry on as a periodic tenant, then you're going to have to serve a common law notice to quit. A common law notice to quit has to give at least 4 weeks notice or 1 period of a tenancy, whichever is longer. And when I say 1 period, that means the way the rent is calculated. So normally it's a month. And that notice must expire at the end or beginning of a period. So it will have to expire either the day before the rent is due or the day the rent is due, one of those 2 dates. And the tenant will then need to leave. If the tenant doesn't leave at the end of the fixed term and won't go, you can simply go straight to court for possession. If you serve a notice to quit, and at the end of the notice to quit, the tenant hasn't gone, you can go to court for possession. There are no alterations again in respect of COVID, so you can just issue proceedings. Although it's usually best to get some specialist advice around this kind of stuff. And then break clauses. Yes, so break clauses are very common in these kind of agreements, obviously. If you want to use a break clause, then you merely need to write a letter to the tenant, either to the company, of course, so that will need to either go to the property or to the company's registered office address. I would usually use both, informing them that you're terminating the tenancy in reliance on the break clause and giving them whatever period of notice is required by the break clause. I should point out that break clauses are incredibly strictly interpreted by the courts. So if you write it wrongly, such that it's unavailable to you or impractical to use, the court will not rescue you. So you need to make sure they're correct and you need to be very careful with them. I see lots and lots and lots of break clauses that are ineffective and unusable because they've been written badly. Usually where people get creative and try and write clever bits of drafting and use long words. Always avoid long words when shorter words are available to you. So it's usually a case of people swallowing a dictionary and coming up with weird and wonderful stuff. So those were the main things I wanted to talk about. I'm happy to take a few questions. I think we've got about 5 minutes left to go. Tessa,
yes, that's right. I was just wondering perhaps if you could just mention about the company registered office. Presumably you can always serve any document and court proceedings at the company's registered office, and that will always be good service?
Well, it depends. Court proceedings, yes. Your tenancy agreement, though, should specify where service is permissible, and the service clause in your tenancy agreement will rule. Normally, companies can be served at their registered office address or any place where they do business in the jurisdiction. So if you're serving, I don't know, a company that has because most companies, especially smaller companies, will tend to have their registered office address at an accountant's address, but you can serve that address, but you can also serve them their place of business, and usually in practice you would serve at the property as well. So you probably just, I would tend to go for the belt and braces approach and write to all these addresses. It is a problem often with small companies serving them because you tend to find that although they've done a deal with their accountant to put their details on the down as their registered office address, the accountant's not always very efficiently passing on post, so things tend to get lost.
Okay, we've had a question here about tenant fees. If tenant fees are not banned, could any management costs associated with arranging and executing repairs be billed to the company as they arise or deducted from the deposit?
Well, that's the case anyway, regardless of what the of the Tenant Fees Act. I mean, you can, if there are management costs associated with arranging and executing repairs, you can charge a tenant for them anyway. So I don't think it's a Tenant Fees Act point really. But yes, I suppose you could do them as they arise. Yeah.
Okay. How much notice do you need to give if writing to activate a break clause? Well, that will be in the break clause, won't it? You have to read it.
Yeah.
At the end of the fixed term, will the tenancy automatically roll over to a rolling tenancy?
Well, no, not in the sense that means. I mean, yes, it will if you let it, but you should normally ask the tenant to leave. Company let tenancies are not covered by the Housing Act 1988, so they don't automatically roll on. They will roll on as a matter of common law if people allow them to roll on, i.e. the tenant pays the rent and you take it. If you tell the tenant they've got to leave at the end of the fixed term, then they've got to go.
If you want them to go, but you want them to pay while they're there, can you prevent a rolling tenancy being created by saying that you accept any rent as mean profits and without any intention to create a tenancy?
Well, yeah, at that point you're not accepting rent. You're asking them to pay a daily charge for use and occupation. So yeah, a tenant who's coming to an end of a fixed term, the normal thing to do would be to write to them. Would be to say, your tenancy is coming to an end, and I'm not intending to renew it or allow it to extend. If you remain beyond the fixed term, then I will require you to continue to pay a daily charge for use and occupation.
Mm-hmm. Okay, and sort of set out what that is, which will presumably be the same as the proceeding. Diane says, I have a tenant who's paid up front for a year. If they want to stay on, when do they need to discuss with me? Also, do I need to serve notice 6 months in advance of the end of their term? I think Diane's getting this muddled up with ASTs. Yeah,
it's not an AST. So if it's a company-let agreement, then they should be leaving at the end of the year. And no, you don't need to give them any notice to go. They just need to be told to go.
Betty says, can a property management company serve notice? Presumably that's the notice to quit.
Yeah, I mean, this is an interesting one, actually. Yes, they can, but they must be very clear they're serving on the landlord's behalf. There have been cases actually involving break clauses where agents have simply said, we are giving you notice, and the courts have held that they're defective. So it's important when an agent gives notice, and this applies in general terms, actually, that they should really be saying, on behalf of our landlord, we are serving you with a notice to terminate the tenancy.
Okay. We've also, very quickly, had a question about a subtenant. If a company has a subtenant under AST, does the landlord take responsibility for the tenant if they don't leave? Quite a long answer to that, really.
It depends. If a company has a subtenant under an AST, well, that's really a rent-to-rent arrangement. If you've agreed for a company let and you've agreed that they can sublet on ASTs, one, you shouldn't have done. Two, if the company has the tenant, it depends on the wording of the company let agreement. If the company let agreement says they have to provide you full vacant possession, then it's up to them to obtain full vacant possession. If it doesn't say that, or you terminate their agreement anyway, then an AST tenant will be inherited by a landlord because of Section 18 of the Housing Act 88. Yes.
Okay. I think we've just got a few minutes. Vera said, I'm often approached by companies running service departments. As the tenants change frequently, they do not agree to updating me on changes in tenants. They also do not want to pay any deposit and use letter of credit. What's your view?
My view on that is it depends how good they are. I mean, they're not paying you a deposit and giving you a letter of credit, you might as well not have it. I mean, the letter of credit means nothing. It doesn't add anything to the tenancy agreement that already exists between you. All it does is it means that any financial security you have is reduced by the sum of the deposit. So I suggest you make sure you're very, very confident that they do actually have the wherewithal to pay you and aren't going to evaporate like smoke when somebody actually asks them for money.
And then finally, I think this better be the last question. We've had a question from Gemma, who asks if you can serve notice by email if this is detailed and agreed in the agreement.
Yes, absolutely.
Although
but in your agreement, and I would be very cautious with those clauses. I often see that it just says, "Oh, you can serve notice by email." It would be far better to be far more specific about the email addresses, the subject line in the email, and also have something in there about bounce backs and making clear that if it ends up in junk mails or spam, it's not your problem.
I have to say, as an old-fashioned solicitor, I would probably serve it in multiple ways by email and have someone go around and stick it through the letterbox as well, so you can prove it's been received. But that's me being an old-fashioned solicitor.
Yeah, I mean, there is a problem with email. People want to use it, and I completely get that. It is difficult to make email work, but the reality is that email service is possible, and we do need to find a way to make it happen. There are ways of doing it. You should be a bit more specific about how it is than most of the clauses I see.
Okay. Right, well, we've reached the hour, so we better stop now. Thank you so much, David, for coming along and talking to us and giving us the benefit of your wisdom on company lets. And we will be back with David in a couple of weeks' time when he will be talking about consumer law, which is a lot more important than people think. So thank you, David. I shall close down now. Thank you, everybody, for attending.
Thank you.